And there was a reliance there on...
Councillor, the audit and all related events were some time ago, were they not? To what extent is it reasonable to expect the party in this instance to remember across some length of time, and is it obvious that today's policy is the same as what it was several years ago? Now, how do you get over the time lapse issue?
In the time lapse, the clause 12 under the contract sets out the explicit standard that needs to be met to ensure that these goods could be resaleable. And it is this same clause which was extensively discussed between the parties in the 2008 audit. And so we can see that the moment that Claimant contracted with Respondent, it knew that this was the same clause, it knew that this was the same policy. And so it had to comply with that particular policy.
Just to pick up for a minute on the word explicit, which you used in your statement, and looking at the breadth of the language in paragraph 12 of the contract, it is difficult to read that as being explicit. And if you look at the policy that accompanied the contract, I guess it wasn't attached, but had previously been delivered on page 52, the language is different. And applying the contract principle of the specific governs over the general. The policy talks about the production of the goods by the counterparty as opposed to the business as a whole. So should we be looking to whether or not there was child labor in connection with the goods themselves as opposed to the business as a whole based on the policy?
Firstly, the business of Respondent here is production of goods. So it knows that this goes to the whole entire business. But more importantly, this particular policy was extensively discussed between the parties. So whilst there may be some reference to only goods in that particular clause, it is those discussions which then take precedence under Article 9 of the CISG, because it is an established practice between the parties that the parties must be held to. That established practice was to ensure no use of child labour in any facet of their business.
So you're suggesting we should ignore or go to what you would argue is the intent of the parties based on conversations over the words production of the goods in the policy statement?
Certainly. As I stated, this was something extensively discussed. It was something the parties agreed to here. And so that specific agreement will then come before any particular wording and expands that meaning of the wording within that particular clause.
Should we give any deference to the principle of contra preferentum? This was, I gather, the claimant's form contract that was used here. And to the extent we find ambiguities, shouldn't we read it against your client?
Contra preferendum applies to the contract itself. And the contract, the explicit wording under Clause 12, states to the whole of the business. So in terms of the construction of that clause, we can see that it, in fact, supports exactly the position of Claimant here, that it applies to the whole entire business. And as I said, in regard to that specific wording of that policy, that was expanded upon, that was agreed upon, extensively discussed between the two parties here. So Respondent entirely knew of the standards that it needed to comply with, and that was to the whole of its business.
Councillor, I'd like to perhaps go back to a point. I didn't think you fully persuaded me, so let's try again. In respect of something like a bank or a stockbroker or financial institution, that they have to comply with a very onerous regulatory regime, and they have large compliance departments to ensure they do. If your argument that sellers to the Yes Casual brand should have a full understanding of the ethical principles and policies of the buyer and of the brand, are we not heading into territory where the clothing manufacturer now has to staff up a compliance department, and is this something that is commercially reasonable, or is it even common sense at all? I'm not with you on this at the moment, so please help me.
If I can use your analogy of compliance departments, compliance normally extends to legislation in these areas, and that's because legislation, unfortunately, as much as it should be known by everyone, it is not. And so it is then incumbent upon parties to ensure they comply with legislation. This is a different case here, and it's different because we're not expecting Respondent to simply know about these ethical procedures. These ethical procedures have already been discussed by the parties in 2008, and not merely just mentioned. It wasn't a piece of paper simply handed over. It was the fact that it was discussed and they explicitly knew what they needed to do to ensure compliance with that policy. So in terms of international business, that is the preferable way to go, to sit down, to discuss what is needed and come to an agreement. It's exactly what the parties have done in this case. We can see here that because of that express knowledge of the high ethical requirements from the label, from the Yes Casual brand, from clause 12 of the contract, that there needs to be a high ethical standard which is adopted. That has been breached, and that is a fundamental breach. And this brings me to my third step. Article 25 of the CISG has 3 elements, and those 3 elements are the substantial detriment, depriving of what was expected under the contract, and that the result would be foreseeable. In regard to the substantial detriment, the Secretariat commentary on the CISG states that we may look to the value of the contract in comparison to the value of the harm. Here, Claimant contracted for $550,000. It ended up paying $850,000 to Domasirin and $700,000 to Oceania Plus. That's a total of over $1.5 million, 3 times the amount that was contracted for and explicitly contracted for under the contract. That demonstrates in itself a substantial detriment to Claimant. In regards to depriving of what to expect, Claimant contracted for goods to uphold the ethical standards of the brand, and instead it has ended up with the trust of the buyers in Oceania being destroyed and a loss of that entire market. And in regard to foreseeability, we can look at what the parties here knew about the different parties involved with this contract.
Councillor, in respect of these payments made to affiliated or at least related companies, is that something that we should be giving consideration to?
Certainly it should be, because that is the harm which has been, or the substantial detriment which has been incurred by Claimant here, and that is that they have had to pay extra money because of Respondent's breach of the contract and failure to uphold the ethical values. In terms of foreseeability, as I mentioned, we can look to the knowledge that Respondent had of the different parties. Respondent knew that these goods were going straight to market in Domasirin stores, as I've mentioned at page 7 of the materials. It also knew that Domasirin and Oceania Plus had interests in those shirts, and that comes from the contract itself. So it's entirely foreseeable that any non-conformity at the production end would straight away manifest where those goods were to be sold. And so because of that, it's entirely foreseeable that due to a non-conformity, that Domasirin would seek to recover from Claimant, and then of course Claimant would then wish to seek to recover from Respondent. Because that is known, it's entirely foreseeable.
Weren't there a series of events that would be difficult to describe as foreseeable here? To have a TV program put on just a matter of a few weeks after the goods arrived in Mediterraneo, revealing this labor issue, that is not really foreseeable, is it? And the public reaction was quite extreme compared to, I gather, reactions in other situations with other sellers of goods. So how can we find that to be foreseeable?
The foreseeability here is in regards to whether or not the goods themselves conform to any purpose which was made known to them. So if the goods themselves did not conform to that purpose that was known, and they were then sold in that market, it's entirely foreseeable that there would be damage which would be claimed, and it would be claimed backward from the domiciliary and then on to claimant and then on to respondent.
Councillor, you're beginning to run a little short of time, so perhaps you'd like to move towards some conclusions.
Certainly, I may. Before I do, I note the Tribunal asked for some information on Article 82 of the CISG, and would you like me to address that in any point?
If you could, briefly.
Certainly. Article 82(1), if I may paraphrase it, simply states that claimant in this instance must give the goods back, and it loses its right to declare the contract avoided here. It does not apply, though, under 2, for 2 parts. Under A, if it is the impossibility of making restitution is not due to his act or omission. And B, if the goods have been sold in the normal course of business. And here we have 2 points. Some of the shirts were sold in the normal course of business, so it's impossible for those particular goods to be sent back. The second is in regard to page 54 of the materials at 21. We can see here that claimant continually tried to ask respondent to take these particular goods back, and it continued to refuse in this instance. Because of that, this is not due to any act or omission by claimant here. It is the act of respondent in refusing to take those goods back, which means that the restitution of those goods was impossible in this case. So to sum up, as I said
Before you do, I just had one last question. I'm sorry, it's very brief. But taking you back to Article 35B, you used the word expressly as you made that point, and my question is, are you relying only on the purpose, the particular purpose being expressly made known, or also relying on impliedly made known?
Both. Here we can see there's impliedly made known through the use of the yes casual brand under clause 2 of the contract, and expressly made known through those explicit considerations that the 2 parties had during the 2008 audit. To summarise, as I said at the beginning, respondent's use of child labour was a grave breach of the high ethical standards that it pledged to uphold. And as it has not done so, claimant rightfully avoided the contract and should be granted the damages that it seeks. Thank you.
Thank you, Mr. Hall. Mr. Schommers, the floor is yours.
Yes, thank you, Mr. Chairman, and good morning. Once again, members of the Tribunal, good morning. Opposing counsel. I'd like to address the issues in the same order as opposing counsel did. Firstly, referring to Article 35, Section 2, Subsection B, CISG, and then coming to the fundamentality. And if the Tribunal wishes, afterwards, as I understood, shortly address the question of foreseeability of damages, maybe. First of all, under Article 35, Section 2, Subsection B, CSG, respondent had the duty to deliver shirts fit for the particular purpose. However, opposing counsel did not read that clause in its entirety. After the section about making a purpose known, it also continues saying, except where the circumstances show that the buyer did not rely or that it was unreasonable for him to rely on the seller's skill and judgment. And as Madam Arbitrator correctly pointed out, it is kind of questionable to impose a duty to research, to look to the pages of the mother company of a buyer in order to find out what standards should be met. And in line with this, there is a decision, one of the landmark cases of the CISG, the New Zealand mussels case, decided by the German Federal Court of Justice. There, a Swiss seller had to deliver mussels to a German buyer, which cadmium content exceeded a soft law standard set in Germany. And in line with this decision and consecutive decisions, there's a general principle in the CISG that it is unreasonable for the buyer to rely on the seller's skill and judgment, and in our case it's particularly the judgment, if the content of that particular purpose, if the particular foreign standard referred to was not made known explicitly, whether the standards, or whether the standard does not apply in the seller's country as well, or whether the seller had knowledge about these standards due to special circumstances. First of all, I'd like to address the explicit knowledge about these standards. And I would like to re-emphasize what we're talking about here. We are not talking about the standard that child labor is an unethical conduct. We're talking about the standard that employing one child anywhere in your facility renders all your products, all the products that the entire company produces, entirely unresaleable. And that standard is certainly not the same standard as Nordkoreaner. And there was also no explicit knowledge, mention of that standard, because all the parties we're talking about, in particular in the audits and the compliance process opposing party mentioned, were the standards of the multinational group of Oceania Plus, not the standards, the national standards of Oceania. Further, Claimant's counsel referred to Article 12 of the contract, and I would like to do so too. Madam Arbitrator already pointed out the language of that clause, and if I may bring your attention once again to page 12 of the record. Article 12, the policy clause reads that it is expected that all suppliers to Oceania Plus Enterprises or one of its subsidiaries will adhere to the policy of Oceania Plus Enterprises, that they will conform to the highest ethical standards in the conduct of their business. So we have, it is expected, highest ethical standards, and conduct of business. So we have at least three phrases which are not definite, because what exactly does an expectation impose on a party? Where exactly do highest ethical standards start and where do they end? And what does conduct of business mean? And opposing counsel argued that this clause was so definite that Respondent had to know that by employing children anywhere in its facilities, it breached a particular purpose.
You know, isn't that a fair assumption? Your client did sign the contract with that clause in it. If they didn't know what it meant, presumably they would have asked. So isn't it a fair assumption that they knew what it meant because of the prior history that your learned counsel pointed out, opposing counsel pointed out?
Well, in fact, the submission is that Respondent knew what it signed when it signed the contract, but that it's not what opposing counsel argued it is. And that is particular if you come to these last four words of Article 12. It says, in the conduct of their business. And when we interpret that, there are different conclusions which we can reach. And you already pointed out that before it comes to conduct of business, it only says the policy for Oceania Plus Enterprises, and that policy only refers to the production of the goods, which was entirely clean from child labor. So we have to interpret reasonably once again under Article 8 CSG what does conduct of their business mean. And I'd like the tribunal to consider first of all that for Respondent it would have been entirely economically completely unreasonable to have its entire business bound by a single contract, a contract for $500,000. And second, that at the time of the conclusion of the contract, Claimant was in desperate need of a supplier being able to handle the order on a rush basis. Now requiring all suppliers to adhere to the highest ethical standards in each and every business operation would practically compel any potential supplier to examine the entire production process, examine the entire business, so to undergo a complete labor due diligence before contracting.
You know, if your client felt that was an unreasonable process to require, maybe they shouldn't have entered into the contract that had this language in it, which seems to, on a plain reading, require ethical conduct with respect to the entire business.
Well, with all due respect, interpretation of the wording conduct of their business does not say that highest ethical standards have to be met in each and every part of their business, and that this interpretation is just coming from the point of view of a reasonable business person would be too far-fetched. And it is also, in our opinion, quite contradictory that Claimant argues about the utmost importance of ethical standards. And Mr. Chairman already pointed out that Claimant did not undergo a compliance in this regard or something. And I'd like to remind the tribunal that under Claimant's own policies, it was supposed to re-audit Respondent before contracting because, unfortunately, there were allegations of child labor within the last audit in 2008. However, it did not re-audit Respondent. And even in 2011, when it became public that Respondent might once again be involved with the issue of child labor, and despite the consequences in regard to, I'm sorry.
Why should their failure to conduct an additional audit lead in any way to our concluding that your client should not be held liable?
Well, in fact, the failure to conduct an additional audit does not form any part of that contract. However, when we interpret Article 12 of the contract, you have to take into account all relevant circumstances as stipulated in Article 8, Section 3 CSG. And one of the relevant circumstances is that claimant did not comply with his own policies in regard to ethical standards.
And therefore it's relevant to our analysis because
we are actually talking about a question of allocation of risk here. And on the one hand, we have Respondent doing what it can to avoid child labor and taking efficient measures to do so. And we have Claimant using a standard contract, not caring about re-auditing its suppliers, and now relying on the utmost importance it places on ethical standards. And that, in our opinion, appears contradictory. And in particular because in 2011, and despite the consequences in regard to Oceania Plus and Domiciron, Claimant did not re-audit the supplier of the replacement purchase, which is Gold Service Clothing, although its own policies, again, would have required an additional audit. So, concluding that point, there was also no making known of that particular purpose impliedly through Article 12 of the contract. And further, opposing counsel argued that the non-compliance with Article 35, Section 2, subsection B, CSG, constitutes a fundamental breach of contract in our case at hand. I'd like to bring your attention to Article 25 of the CSG, if I may. It states, we may find it on page 57, by the way, in the bundle. It states that a breach of contract committed by one of the parties is fundamental if it results in such detriment to the other party as substantially to deprive it of what it is entitled to expect under the contract. Now, opposing counsel based its argument on the damages caused. However, it is common sense, common opinion of commentators and court decisions that, in fact, that is not the grounds for fundamental breach. Damages may be an indication of a fundamental breach, but they are not the basis for that. That is why the CSG has damage provisions in Article 74 to Article 77. And the tribunal should keep in mind that the CSG being a law tailored for international trade, use it for international trade, the avoidance of the contract is the last resort of remedies, the ultima ratio of remedies that should only be taken into account if there is no other means to compensate damages or damages caused. And in particular, it is therefore usually unjustified if any economic use may be made from the goods delivered, even if they have to be resold at a giveaway price. So in our case at hand, Claimant is an intermediary for the clothing industry, and therefore its main expectation of the contract was to resell the shirts for a reasonable price. And 10 days after the alleged avoidance, it did so, selling the shirts for approximately 85% of the original purchase price. Now, opposing counsel failed to establish why the common breach under Article 35, Section 2, subsection B, would in our case, without any further prerequisite, constitute a fundamental breach under Article 25 CSG.
Let me ask,
Please.
Are you conceding that the price differential is properly recoverable by Claimant in this?
Well, our argument is that there was no breach of contract in the first place, but if the tribunal intends to find that there was a breach of contract, it should also find that this price differential and maybe losses of profit could have been recovered by a common damages claim or a reduction claim, but not by avoiding the contract.
let me go back to the point about substantially depriving of the benefits of the contract. And you were referring to authority that says if the goods could be used for any similar purpose, that's good enough to take it out of that provision. And I'm struggling with that. Is there contrary authority? Because for the purposes of this particular buyer who needed goods that were useful and ethically produced in their country, which is where your client knew it was going, aren't they deprived of, the substantial benefits of the contract?
Well, in fact, they are not. There is authority stated in the commentary of Schlechtem and Schwenzer, written by Professor Schroeter there, that reselling the goods even at a giveaway price already blocks in avoidance. However, there's also another opinion, particularly from the United States of America, that you have to resell the shirts at a reasonable price with reasonable efforts. However, that would also apply here because the shirts were resold within 10 days after the alleged avoidance for a reasonable price of 85% of the purchase price.
So there is authority going both ways, somewhere in the literature, either in case law or in the learned scholarly writings on the subject?
In fact, there is. In regard to the give away price, I would like to refer you to the writing of Professor Schroeter, and in regard to the reasonable resale, it would be Professor Honnold then, in his commentary.
So we would have discretion if we were to conclude that for this particular buyer, this was a substantial deprivation, even though it could be used for its general purpose.
Well, as also even the lower threshold established by Professor Honnold only says that you have to make reasonable use out of the goods. That would also not substantially, we would not have a substantial deprivation of what claimant was entitled to expect under the contract here, because it made reasonable use out of the goods and it could have recovered damages instead of avoiding the contract, keeping in mind that this contract avoidance is the ultima ratio of remedies. So I would like to shortly address the foreseeability of damages, which was also raised by opposing counsel, but in regard to the Article 25 argument, however, which is now opinion not part, the damages are not part of an Article 25 argument, but should be part of an Article 74 argument. And Mr. Chairman already established that it is questionable whether settlements should be recoverable under the CISG, and in fact they are recoverable in the CISG, as established again by the German Federal Court of Justice in the used car case. However, the prerequisite for this recoverability was that it was a liability, and also liability of claimant to the other party, and that this liability and the consequences following from that were foreseeable for the seller, for respondent. And in regard to foreseeability, I would like first to bring your attention to what kind of damages we are discussing here. We are mainly discussing goodwill damages. And goodwill seems to be a particular problem within the CISG, because we don't have one society and two companies sitting at society having the same moral and ethical standards and the same interpretation of goodwill, but we have two companies from two different countries where ethical standards, interpretation of ethical standards, and the interpretation of business value and business reputation differs from society to society.
But in the contract, there's the reference to the highest standards. So if one was able to assign a numerical ranking to them, if country A is ranked 85 points and country B is ranked 90, then isn't 90 higher than 85?
It is, in fact. However, Article 12 does not refer to the reputation of the companies involved, but only refers to standards to be complied with in the production of the particular goods. And particularly keeping in mind that respondent had no knowledge about the corporate structure of Oceania Plus Enterprises, Article 12 cannot be held to respondent's detriment in this regard. And Madam Arbitrator also raised her concerns in regard to the chain of events that led to these damages. And I would like to re-emphasize that this chain of events, which has to be foreseeable under Article 74, sentence 2, was in fact not foreseeable for respondent, because we have such an extreme reaction in the public. And